From the Sunshine State, this is Tampa Bay's 10 Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock, and that means you are here listening to FLALAW on the radio. This is a live legal call-in talk show brought to you by my firm at Perinick, Caulfield, Averill, and Noyes. We are the first personal injury law firm in Tampa Bay. We've been helping people since 1955, so we're celebrating our 71st year. And one way of giving back to the community is by presenting and providing this show to you, our listeners. This is live, as I said. There's 3 ways to get in touch with us tonight if you have a question regarding the law. First way is an easy way. Give us a telephone call at 727-441-3000. Or you can watch us live on Facebook on our firm's Facebook page at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. And you can type your question right in there, too, if you have a question. And the third way is to buy our YouTube channel as well. And that's the same tagline of Perinick, Caulfield, Averill, and Noyes Injury Lawyers. And Ed on the other side of the glass will let us know if you type in a question over on our YouTube channel as well. So, and I keep saying us because I am not alone. I am here with a friend of mine and a returning guest by popular demand. Jake Blanchard is here. I am here to talk about personal injury, workers' comp, Social Security, disability. But joining us is Jake Blanchard with the Blanchard Law. He's a Florida licensed attorney focusing on bankruptcy, credit debt, debtors' rights, and business litigation. He has been recognized in Super Lawyers and Best Lawyers for his bankruptcy practice and litigation work. Jake, thanks for coming back to FLALAW by popular demand. Please reintroduce yourself to our listeners and explain why you practice in the areas and who do you help.
Well, thanks for having me back. And if popular demand is by just by my mom, I don't know if that counts, but I appreciate.
I demanded you to come back too.
I appreciate that. Yes, I mainly practice bankruptcy law. I do consumer law and small business bankruptcy law. And I've been on the radio show with you now more than a few times. So I'm not as nervous as I once was, but
you do a great job.
But so it's nice to be back, and I appreciate you having me.
Sure. And so what we're going to do is just going to really jump into the areas of law that you really specialize in, because I think all those areas are so important to our listeners. And so let's first tackle initially talk about bankruptcy. You have been helping people for a long time with bankruptcy matters. Can you share some common signs someone should be looking out for to differentiate between whether or not this is a blip on their screen or whether there's some concern to take steps to prepare to consult with a bankruptcy attorney?
Well, so funny enough, I beat myself out of attorney's fees all the time by telling people this, but bankruptcy should be a last resort, right?
That's a sign of a good attorney, though.
Well, it should be, because it's not something that you can just flip a switch on and off with. So there does become a time where, I say this is time to do it, right? Because, a lot of people call and a lot of people file bankruptcy for mainly what I call 2 different reasons. One, I would call like a legal pressure, where they have a foreclosure that's pending, the repo man circling the neighborhood looking for their car, their wages are getting garnished, and they need that automatic stay that the bankruptcy offers just to get the breathing spell. So those are what I call legal pressures. The vast majority of my clients, though, they file for what I would consider psychological pressures, in that they're getting collection notices in the mail. They are way behind on credit cards. They are afraid to answer the door because it's going to, could be a process server. So those are the folks that just call out of desperateness and like, want to get to the point where they don't have to worry about picking up the phone or answering the door anymore. Both of them are very, valid reasons,
Sure.
right? And I don't recommend waiting until there is that legal pressure that forces you to file, but there is, sort of a projected, timeline from when you start thinking about, as you said, and that was a great lead in, when you start maybe thinking about, do I need to file bankruptcy? When you start having to pay credit card bills and it becomes such a burden that you start using the deals that they have, where you could roll it into another credit card and not pay interest for a little bit, and then roll it into, so they do the credit card merry-go-round kind of thing.
Oh, yeah.
And so eventually that'll end up stopping. The other thing is, especially with consumers, is if there's an event in their life, whether it's a divorce or a health issue, or they lost a job, naturally the credit cards are a backstop, right? So a lot of people end up just kind of using them as that backstop, and then they sort of carry forward. And what ends up happening is the interest becomes so overwhelming that they never end up actually like paying any of the balance down. And, there are consumer laws that are trying to educate people about how credit cards work and things like that. But by and large, most people don't have time during the day to sit there and read a credit card agreement and
Sure.
try to figure everything out.
Especially when they're in that desperate situation.
That's right. And so, but I think that if you're getting to the point where you are making a decision whether to pay your credit card bill or your rent, that's when it's time to start looking at, how do I fix the situation? How do I right the ship? From a business standpoint, we can get into that in a little bit, but it's not that different, right? So if you're, making a decision on whether or not to make payroll or whether or not to pay a loan back, then these are things that you need to start thinking about. Should I go see a bankruptcy attorney?
Yeah, and there's sometimes somebody may lose their job, and but they can secure another job. It may take a few months to do that, and so their car payment or their home payment may be a month later. So
Right.
Those aren't the times that you tell them, "Hey, jump into let's start the bankruptcy process just yet."
No, but we give, free consults that way. We can give a little, give some information so that they know what to look for. They know when things start really getting into trouble. A lot of times people do want to try to pull themselves back to the point where they don't have to consider this. So, but at times it's a snowball effect, especially if you haven't been able to get the job that you've been looking for over a period of time.
Sure.
And you're just having a hard time making ends meet. There's, different variations of bankruptcy that could help you get caught up on a mortgage, or it can help you get caught up on a car and things like that. But by and large, most people really don't start thinking about bankruptcy until they get sued.
Right. And I think creditors, correct me if I'm wrong, creditors would rather you not file bankruptcy than file bankruptcy in certain situations. Is that right?
I think it's different for every case. And so I think a lot of that depends on the situation. But so that's a good point, though, because I do see prior to the lawsuit stage where someone will get in the mail, pay $3,000 on the $10,000 that you own, and we'll walk away, right? So that they do that. So for the most part, yes, you're right. But a lot of creditors, I don't know, I can't really get in their heads on how they think. I did work for a big firm, and I did creditor work for a while. And I think that they are just like anybody else in business. They have bosses to answer to, they have a job to do, and you owe the money.
Sure.
And so I don't think really they care one way or another so much whether or not you file bankruptcy. They just need you to deal with it one way or another.
Okay. And you said something funny because I say the same thing all the time in my personal injury practice. I can't get into the insurance company's head. If I could figure out what they were doing, I'd stop trying to do that a long time ago, because sometimes what they do is kind of crazy. So
Right. They don't. So, and, a lot of people think, the bank should do this, or I'll just file bankruptcy. Well, you don't know what's going into the calculus of the bank, or the thought of the thought process of the bank. You're not there in their head. And so trying to sit there and figure out what the bank is going to do is it's not the best way to go about it. I think you just, if you leave it at, they're just trying to get money out of me. And that's about all you need to know.
Right. If you're just tuning in now, you are listening to FLA Law on the radio. We are live right now from 5 until 6 o'clock here on the radio. My name is Matthew Noyce, and I can attack any questions that you have regarding the personal injury law. And Jake Blanchard is my guest, and he is here to talk about bankruptcy and other matters. So this is the time to jump on the line if you wish to. It's 727-441-3000. But Jake, we're talking a little bit about bankruptcy, and could you explain to our listeners, the main types of bankruptcy a person can file, and then whether or not they're different for businesses to file?
Sure. From a high level view, there is different types of bankruptcy. They're divided up among bankruptcy code chapters. So chapter 7, if you ever hear somebody talk about that, that's like a straight bankruptcy. That's where it's a liquidation. Essentially, a debtor's going to the bankruptcy court, or to a chapter 7 trustee, turning out their pockets and saying, this is what I got, right?
Yeah.
So in that instance, if you can think of a giant bucket like dropping out of the air and landing in your front yard, and then everything you own going into that bucket, that's the bankruptcy estate, right? So then a chapter 7 trustee is appointed over that bucket. And so their job is to root around in there to see if they can sell anything, or bring anything back in. Like if you paid a family member back in the last year, or if you transferred something out of your name in the last 2 years that you shouldn't have, they have the ability to potentially bring that in. So they have that bucket, and that's the world, right? That's the bankruptcy estate. You're allowed to take stuff out of it, though.
I was going to ask you, there's things that can be excluded from the bucket?
Absolutely. And those are exemptions. So the exemptions in Florida, for the most part, everything here is general, because generally speaking, I mean, there's always,
Right,
you remember that. Yeah. Yeah. It depends. And generally.
That's
so
right. Typical lawyer answers.
Yeah, exactly.
That's right.
But you can take out, in Florida, your homestead, your house. But then if you, from a personal property standpoint, you don't get much else after that. You get $1,000 personal property and $5,000 worth of a vehicle. You can take out of the bucket your 401k, your IRA. You can take out the, health aid that you need. Certainly you don't need to leave your glasses or your hearing aid in there,
Okay,
right? Not that you have that, Matt. You're too old. You're not old enough yet.
Right here.
No, you don't have any of that. So you're good. But
Thank goodness we're on the radio and not on TV.
Yeah. But so you're only left with a certain amount of stuff. And by and large, believe it or not, most people fit in that bucket. Most people fit into that, that's all they really have. And that's a lot of people that end up filing bankruptcy and need a fresh start. If you don't have a homestead exemption, you get to take $5,000 worth of what they call a wild card, which would be, anything else you own, right?
Okay.
So in Florida, the exemptions are really forgiving as far as the house, but not so much anything else. So the other type of bankruptcy is what would be called a Chapter 13 that individuals can do. And only individuals can do a Chapter 13. And that is somewhat like what some cases would call like a rehabilitation. And it's a payment plan, right? So that is and the plan payment is usually over 3 to 5 years. Typically it's going to be over 5 years. and it's based on what would be left in that bucket, right? If you had to buy something back out of that bucket, right? Or your income or your income. It's a combination of the both. And that requires a certain amount of lifestyle change. That
Sure.
requires not eating out as much. That requires some real thought going into what can I afford and what can't I afford, because the bankruptcy code for the most part, when determining these types of plan payments, they go by standards. They go by like hard-boiled IRS standards that are baked into the whatever computer software program your attorney's using to determine what your payment is. So you put in the information, it spits out a number, kind of thing.
Okay.
And you take out you push the line and you take out as much expenses for health insurance or extra for a house if it costs a little bit more. But there's a Chapter 13 trustee whose job is to squeeze as much as they can out of that limit.
Sure. Yeah.
To pay over 5 years. So it's a push pull kind of situation. At the end of the day, the Chapter 13 plan payment has to be doable. It has to be feasible. So if it's not, then you're left with going to a 7, or you're left with dismissing the case. But not everybody can file a Chapter 7 that has consumer debt, because Chapter 7, you're in and out in 4 months, right?
Okay.
And so that's what everybody wants to do. They just want to get it in, get out, get it over with.
Fresh start
Immediately. Immediately. But there's what they call something called the means test, which is really a lack of means test, where they compare your household income, whatever your household is, to the median household income that the IRS or the U.S. trustee puts out. So, and if you're above a certain level, you can't do a Chapter 7. If you're below the certain level, then you can. And a lot of people, it's pretty scary, but a lot of people fall below that level and can file Chapter 7.
Oh, wow.
Yeah.
I imagine, especially nowadays, times seem to be a lot tougher for so many more people.
Yeah.
And so I can imagine your phone's ringing quite often.
Well, it is, but at the same time, it's one of those things that bankruptcy will always be there.
Right.
The economy, as they say, is cyclical, right? It's sort of like a bell curve. But people always have problems, always have issues. Nobody's perfect. Everybody should get a second chance. And so, that's really what the system is for. It's for the honest but unfortunate debtor. And regardless of the economy, you're going to have people that have fallen on hard times, because the economy in itself, if you look at it, we talk about it in a macro sense, but really it's your household.
Right.
What is your household
That's
economy?
Your household economy. Yes.
Right.
No,
So, that
sense.
is quite independent from the rest of the world, believe it or not.
Right. And certain things that may not impact others and can impact your family, a medical condition can really have a dramatic effect.
That's right.
On the need to consult with a bankruptcy attorney.
Correct. Or again, loss of a job or divorce or something to that effect. A lot of times people do make mistakes too. Believe it or not, we are human. All humans are imperfect. Right. So we do make mistakes, and it gets the ability to get a fresh start, to have a second chance.
And I think that's wonderful. I think everybody needs to have that, and this gives an opportunity, but not a free ride either.
No.
And I think that's one of the misconceptions
Correct.
that people have.
Right.
Can you share that a little bit more about that misconception and any other misconceptions about bankruptcy and what the type of people who file it and such like that?
Well, so bankruptcy is a fresh start. It's not a head start. So you don't get to keep all your toys and stuff in that bucket and not pay your creditors, right? If you want to keep your toys in that bucket, then you got to figure out a way to either, work out a deal with the Chapter 7 trustee or go through that Chapter 13 payment plan to pay the value. You don't. The system's not made so that you can like I said, get a head start. It's more for it is a fresh start, not a head start. So the anytime anybody, has a consult, I almost have to start off by saying that, because a lot of times there's that misconception that you just talked about, where they heard from their friend that they went through the bankruptcy, they got to keep all their stuff. Right. It was no big deal. No pasa nada.
Easy.
Yeah.
No impact whatsoever.
It's all good. It's all good. Yeah. And why isn't it the same way for them? Well, every circumstance is different, and your friend didn't have, an extra house or whatever. Right, so, right. It's always something there. So, the comparing yourself in any circumstance from this type of situation is not a good idea, because it's very individualized. It's very circumstantial.
Right. And I know we're talking right now about personal bankruptcy, but you also help a lot of businesses with their bankruptcy issues as well, correct?
Yes, I do. How
is that different than personal, if there is a difference?
There is. There's a huge difference. For the most part, the concept of bankruptcy, again, is to get a fresh start or a second chance. And from a business standpoint, that means reorganizing. That means restructuring debt. That means providing a plan to the court that is feasible, that's fair to other creditors, that's fair to the parties in interest in the case, and that can help you go forward. Because the argument to the court is, well, you'd rather I do this, right? This reorganization, and this creditor gets paid less and that creditor gets paid less. The alternative is it this business goes out of business and it goes into a Chapter 7 where it's a liquidation. So the fundamental goal of bankruptcy, for the most part, is to get what's called a discharge. The discharge is a reset of the debt, right? So for an individual, in a Chapter 7 or a Chapter 13, that's the idea, right? It's not different for a business, but a business doesn't get a discharge if it goes into Chapter 7. It dies. It's a nail in the coffin. It's over. So it goes into a liquidation. So that is what is the downside, right? This, filing a bankruptcy, I always tell people, it's not like flipping a light switch on and off. You have responsibilities. You are a fiduciary. You are basically running the business for the benefit of creditors. Yes, you can get paid, but you're under a microscope, and the court is going to require you to provide information on a monthly basis and things like that. So it's not the end all be all. It's not a walk in the park. If a business is going to do a reorganization, the first thing that I always do is make sure that they're always tired when they come in, but I make sure that this is it's a recommitment. You have to re-up yourself. It's like going into the military and signing up for another 4 years. You got to re-up. If you're going to do this, you got to re-up. It's not something that you can just kind of go in and, well, I'll see if it works out.
Right. It's not a phase. I plan on phasing out of my business. If you plan on phasing out of your business, that's a whole different.
It's a different animal altogether.
You got to pull up your bootstraps and say, okay, I'm ready to tackle on this business again under this new approach.
That's right. That's right. You have to re-sign up. You have to sell. You have to buy into yourself, and you have to trust yourself, and you have to trust the people that you work with, and you've got to trust whatever it is you're doing as a business model, whether it's a product or a service. You have to trust that it has done well before. It will do well again. You have to believe.
Right. And there's a lot of national businesses that try to reorganize, and for one reason or the other, they end up not being able to do that. And it may be because the business wasn't able to pull up their bootstraps, and they didn't have the desire to succeed. But it could also be the public who now has this image of they filed bankruptcy, so I'm not going to go to Toys R Us or Saks Fifth or whatever other company it may be.
Well, I don't think bankruptcy has the stigma that it once had. From a national standpoint, Red Lobster filed bankruptcy. but people still like Red Lobster.
Right.
There's, I don't know the fate of it now. The one down the street from me closed, and I'm a little upset. I like you so, but
and that's a good story because I mean, Red Lobster, they got the new CEO, and he really had the gun ho to try to make it succeed.
Right.
I think that's what you're talking about.
Right.
Even if it's
Exactly.
a small business, even if it's the two brothers running the business, both brothers have to have that gun ho to say,
That's right. Yeah.
Let's go restart. Let's keep fighting.
We believe in the brand. We believe in the model. We need to retool. Like there were mistakes in the past. There was money that was spent on things that shouldn't have been. It's like a leaky bucket, right? You have to kind of find the where the leak is in the bucket. Where's the leak? So you got to find out, figure that out, plug it up, keep going and push forward.
I think that's right. Listeners, if you're just tuning in, you are listening to FLA Law on the radio. My name is Matthew Noyce. I'm one of the partners at the law firm of Perrinick, Caulfield, Averill, and Noyce, one of the first personal injury law firms here in Tampa Bay. We have been helping people since 1955, and we help them through their car accidents, medical malpractice, slip and falls, workers' comp injuries, and even Social Security disability. And as a thank you to the community for so much faith they have in us, we like to come here every week at 5 o'clock to 6 o'clock on Tuesdays to be available to answer any questions that you have regarding the law. And we'd like to bring in special guests to talk about other areas of law that we don't handle. And so this week we do have Jake Blanchard here, and he's been so helpful so far in talking about bankruptcy law. And we're going to shift over to creditors and debtors' rights and collections and foreclosures and such. But before we do, I do want to welcome you to give us a call with any questions that you have at 727-441-3000, or jump on our Facebook Live page at Perrinick, Caulfield, Averill, and Noyce Injury Lawyers. Perrinick is spelled Perrenich if you want to jump on there. And you can type in your question right there, and we'll be happy to tackle any question that you have. Even if it's not a question, it's just a comment or a concern that you have regarding any of our areas of law. We truly welcome a discussion about differencing opinions or agreeing opinions, whatever it may be. But that's what our laws, our legal system's all about, is being able to discuss issues and hopefully resolve issues. And so, Jake, again, thank you. Let's move on over to creditors, debtors' rights. Can you briefly explain to our listeners, what protections exist for debtors that are experiencing or facing collection calls or lawsuits? Kind of talked about that a little bit. People are waiting, not answering their phones, not answering their doors.
Yeah.
All right. And so what kind of things can the debtor do, or what kind of protections are there for that?
This comes to a head when a creditor gets a judgment. And a lot of times a creditor will get a judgment. Let's take a credit card. Just to say Bank of the World, making up a bank. And they use the Bank of the World Visa card here and there. Something happened. They used it more. It got to a point where, the minimum payment was $1,000 and they can't pay it back. All of a sudden it's, they're getting sued $35,000 when they probably only used 10 or 15 because of the way the interest compounds. And they don't understand the process. Most people don't. And I probably wouldn't if I wasn't an attorney. And they'll get what's called a default, right? Because they didn't answer the process server, or they didn't answer the complaint. Then they'll end up with a judgment. Next thing they know they're getting their bank account garnished, or they're getting wages garnished. So there are things that you can do that are to enforce your rights that are exemptions. Also, similar to the bankruptcy exemptions, these are things that you can keep, right? So the problem is that what happens, Matt, is it's a shoot first, ask questions later. Like when your paycheck is getting garnished or your bank account's getting garnished, the bank isn't asking that's the garnishee isn't saying, well, is he head of household, or is this a marital account? And from a technical term, tenants by the entirety, so it's his husband and wife. So they're not asking themselves that. They just put the administrative hold on there, and then you got to go in and you got to make your argument in front of the judge why this particular bank account or why your wages shouldn't be garnished.
That sounds good. And it does look, before we go further on that, does look like we have a caller. Anthony has been holding. Anthony, thank you for listening to FLA Law on the radio. How can Jake and myself help you?
Well, thank God it has nothing to do with bankruptcy, but it does have something to do with personal injury.
Sure.
Oh, good. That's you, Matt.
So
Jake is wiping the sweat off his brow.
Yeah, all right.
Okay, cool, great. Back in 2020, I had a slip and fall in a major department store. They were getting the floor fixed. They didn't do it right. Looking for a pair of shoes, fell, got injured, yada, yada, yada. There was two insurance companies that were being sued at the time, the contractor and the store, whatever. Retained an attorney, a friend of mine, and 3 months into it, I can't work. They reached out to me. One of the paralegals asked me if I wanted to do one of these loans against my case. I said, sure, why not? At this time, that attorney was a part of a law group. And what I didn't know at the time was the same person that was involved, my attorney, his wife was the CEO of the same company that was lending me the money, which I guess subsequently found out that was a conflict of interest and that was a no-no. So he at one point separated from his law group and went to work for himself. They asked me if I wanted to stay with that law group or go with him. I said I'll go with him, and then found out that there was a class action suit against everybody, which they had, attorneys called me up and wanted to know if I wanted to be a part of. I said, sure, why not? I didn't know it was illegal what they did. And then when it came time to settle my case, now he put in a demand for $1 million. But at the same time, he's under litigation himself. He may be losing his license to practice law. Somehow, I get the short end of the stick, and he's telling me that I need to settle this thing for $20,000. And did not do any due diligence in the case whatsoever. He was in a panic, and he wound up saying, look, you're not going to win this thing. I don't want to go to court with it. It's a dead duck. It's a turkey, and you'll be lucky to get 20 grand. I think we should just do it. 4 years into it, I got tired, and I said, okay. And we did it. And now I have regrets that I didn't just move to another attorney. Do I have any recourse at this point?
That's hard to say. You touched on several issues that, but I guess the main question you have is, do you have a recourse against the attorney after you settled the case? When did you settle the case?
Shoot. I believe it was in 2025, a year ago.
And because the reason why I asked is because there's only a two-year statute of limitations to bring any legal malpractice claim that you may have. So even if it was clear legal malpractice, if you wait more than 2 years from the date of the malpractice, you're forever barred from making a claim against the attorney. But
I try to speak to this about other attorneys, and there's not a whole heck of a lot of enthusiasm out there, especially in this part of Florida, where one attorney is going to go up against another attorney. They kind of not want to do that. I was going to address that on two things too. I was going to say you may have to reach out to an attorney outside of the area because of that purpose. But also, what also is challenging on the claim is that you have to prove that the attorney did something or didn't do something that made you consent to the settlement. Because the argument's going to be, hey, I told him what I thought about the case, and ultimately Anthony said that he wanted to settle it, so it was with his free will that he settled the case. And so that's the burden that you have if you bring a claim against the attorney, is that you have to show
the jury, or if you went in front of a judge, the judge, what that attorney did that made you make the decision that you made. And had you known X, Y, or Z, you would have made a different decision, but he failed to disclose that. So It is a tough case. Legal malpractice, just like medical malpractice cases, are tough cases, but that does not mean you don't have a claim. But it would be a challenge, especially you have one in this area, because I think that was probably a Clearwater attorney. So you'd probably want to reach out to somebody in Orlando or in the other area of the state to see if they can do it. Anybody in the state of Florida can represent you in legal malpractice claim in the state of Florida.
Okay. Well, they wound up, they settled the case, the class action suit. Which they were found guilty of, obviously. All of the attorneys involved in that, and if I knew that this guy was under that kind of microscope and under that kind of pressure, I would have definitely went with another attorney before. I found this out, pretty much during and pretty much after the fact.
Yeah, right. Yeah, and so those are issues that the attorney would have to consider when they're determining whether or not there is a claim to be made for legal malpractice. It sounds like you have really two claims: one against the legal malpractice for this slip and fall or trip and fall, and then the class action, which are two separate cases. But I do wish you the best. I do wish you the best on that.
Well, there's no way I could readdress the slip and fall deal. I mean, they're pretty much out of the blue.
Correct. I mean, that's correct. I mean, it would be the legal malpractice stemming related to his representation in the slip and fall case.
So the best thing I could do right now is try to find any kind of attorney that is not having lunch with this guy on a weekly basis,
or is familiar with them. It's always better. We have to do that in our medical malpractice cases too. We can't get a local doctor to say something bad about
of course,
another doctor. So it's not impossible. I do wish you the best, and I certainly appreciate you listening to FLA Law on the radio.
That was an interesting case. Right. That was an interesting call. Thanks, Anthony.
All right, guys. Thank you.
All right. Take care. It does free up a line, so if you have a question, we are here, 727-441-3000. Before we took Anthony's call, we were talking about the protections that debtors have. And one of the things that I hear about, and correct me if I'm wrong, is that there are certain time frames that a debtor can call a creditor can call the debtor. You can't call them like at 10 o'clock at night,
right,
and threaten them. Is there other types of protection?
Yeah, there are, but they relate only to consumers. There isn't that sort of limit on contact for businesses.
Okay.
But by and large, business creditors still play by those rules to the extent that they think that they need to. But there are consumer protection laws out there that say, the Fair Debt Collection Practices Act says that you can only call between a certain amount of time during the day.
Okay.
That you can only call a certain amount of times during the week. They say that if you tell the debt collector that you have an attorney, then they have to call the attorney. But then you better make sure you actually have an attorney,
right,
because then they'll come right back if you don't.
Can they call you at work?
They're not supposed to a certain extent, but I don't know exactly how many times they can, but when you file that application, like, you're giving them permission to contact you. So when
an application for a credit card,
correct, or whatever, for a line of credit, for a business loan,
sure,
or whatever, you're giving them permission to contact you. So they initially, yes, but if it becomes a point where it becomes a problem with your boss, or it becomes a problem with your work, obviously they can't interfere with your business life. They can't interfere with you making money. Otherwise, how are you going to pay them back? But regardless, there is a certain amount of what they call tacit allowance for them to say, okay, well, you put your work number on there, that means I'm going to call you at work. But there is limits.
And how can the debtor,
mm-hmm,
how can he protect himself or stop those phone calls from from coming in. Does the application for bankruptcy, does that immediately
No.
stop the phone calls?
No, the audit. So when a lot of people file, the reason why they file is what you're touching on, and that is to stop the creditor harassment, and that is called the automatic stay. When an individual or a business files bankruptcy, the automatic stay goes into effect. It's under the bankruptcy code, and it says that creditors can't contact that debtor.
Okay.
Right.
Right.
So the creditor can get an attorney and contact that debtor's attorney, but the creditor cannot directly contact that debtor. So then the phone calls stop, and that will last through most times through the duration of the bankruptcy. And obviously for the Chapter 7, it's at the end of it, you're getting a discharge, they're not calling you anyway.
Right.
So, and same thing with a individual Chapter 13, you're making your payment plan, payments over the 5 years, you get to the end, you get your discharge, they're not calling you. So they're not calling you while you're making the payment plan, they're not calling you while you're in the bankruptcy process. But that button doesn't get pushed, or that doesn't come into effect until you actually file and have a case number. So a lot of times, if you'll hear people say, well, I told them I filed bankruptcy, but they still call me, and they asked me for a bankruptcy case number, but I didn't have one. And so I know debt collectors have been doing what they've been doing since biblical times. They know how to collect money. So they're going to ask you, what's your case number, right? So if you do file, have that handy. It takes a few days for the creditors to get notice. It's much faster than it used to be when I first started. It'd take a week or so between, mail and things like that. Now everything is digital, and it's almost within at least a day, or maybe shorter than a day, because of the way the communications between the financial institutions are. So it'll be pretty quick, and you won't have to deal with those calls anymore.
But let's say someone is served with the lawsuit from a credit card company, or even the mortgage company. I know that can be scary.
Yeah.
I'd never like to have to sue the at-fault driver but when their insurance company misbehaves, we have to. Right. We don't get to sue the insurance company. We have to sue the at-fault driver. And so I'm sure process server knocks on their door and says, "Here's a lawsuit."
Yeah.
But in terms of a debtor,
right?
What immediate steps should a consumer take if you receive such a lawsuit or a sheriff's sale notice or anything?
Well, so there's obviously different levels of lawsuits. So if it's what they would call in county court, small claims court, which is under $8,000, that lawsuit is going to have a statement that says how much you owe, who's suing you, and how much it's for. It's going to say you need to appear at this hearing, or you're going to have what they call a default entered against you.
We talked about
and
that.
Get a default judgment. A lot of people don't show up for that hearing, right? So the first thing that they need to do is make sure that they're aware of that, right? Look, is it a small claims court hearing? Is it a small claims court case? If it is, you're going to have a pretrial hearing right there, right on the paper. Anything above that level, which is county and then circuit, is going to have a response time due date. And you flip through the pages, you read it. First thing you need to do is read it, Matt. I mean, you can't just throw it in a drawer, throw it under the desk, and just hope it goes away, right? You have to read it. You have to try to understand the best you can what the situation is. And there's some fundamental things about it that you shouldn't need much of legal acumen to understand. That it says you got to respond in 20 days. Okay, so most people aren't going to know how to respond, and of course they wouldn't. If I wasn't an attorney, I wouldn't either, right? So get a consult. A lot of attorneys, every attorney that does what I do, they give free consults, free initial consults for an hour. And then you can talk about your as a whole, right? Because it's a holistic view. You don't want to just like deal with this one thing. A lot of times, if you're getting sued for a credit card, it's not a one-off situation. There's
Right.
more coming.
Right.
So the whole picture needs to be looked at. Are you behind on your car payment? Are you behind on your house payment? Are you not getting as much overtime? These sorts of things. You need to adjust the budget, what have you. Is there more on the way? And is there a way out of this other than bankruptcy? Like I said at the start of the show, I beat myself out of attorney's fees all the time by telling people this, but bankruptcy should be the last resort. There's time limits on it. You can, for Chapter 7, you can only do one every 8 years, which sounds crazy to say, but it's true. They don't want people coming in time after time into the system and getting a discharge from their debt.
Right. And Jake, one thing we did talk about, we talked about the business owners.
Correct. Yeah.
And one thing that's relatively new in the news, you pointed out to me, was that the COVID relief loans.
Yes.
And let's tell our listeners a little bit about what's happening with those situations, and
yes,
and how it's kind of like a snowball effect, I think.
I'm willing to bet that there's someone out there that everybody knows someone that has one of these loans. What are these loans? They are the economic disaster loans that the SBA put out when there was COVID. Right. And so the SBA does economic disaster loans from time to time. They've never done it on such a large scale. $328 billion went out the door.
Wow.
Even more went out the door. That's what's not coming back in.
Oh,
so
okay. Yeah.
The issue has been these loans, they have great interest rates and it seems like a good idea at the time, but guess what? It's a loan. You have to pay it back. They're not forgivable, right? They're not like those paycheck program loans that people got. And it's really very difficult it's almost impossible to work a deal out with the SBA outside of bankruptcy.
Okay.
The SBA wasn't built to service this level of loan service, and it's coming to a head. So to this day, every day I get somebody calling me. I have an EIDL loan. I can't pay it back. I don't know what to do. Can you call and negotiate with the SBA? No. I cannot, because I'm not sitting on hold for 3 hours just to tell them they can't talk to me. And also, the person on the other end doesn't have any authority to do anything other than answer the phone, say hello, send me money. That's it. So you get it, and so many businesses out there are put behind. What I've noticed, this is the break in the trend that you and I had talked about in past shows, where I had said initially, it was the SBA problem, right? So the SBA wasn't suing people. They weren't really doing much other than sending emails and doing phone calls to collect.
Yeah,
now,
don't forget you owe us money.
By the way, yeah,
money.
We haven't heard from you in a month. How are you feeling? Next month, it's a little more serious after that. Normal creditors would have sued you, within 3 months. There's people out there that haven't made payments in years. So now at this point, these loans have grown, they've matured, and they're being sent to Treasury. And the Treasury is basically the collection wing of the United States government, right? And it's the things that we talk about as far as exemption don't apply to them for the most part. So the homestead protection really doesn't apply to them. So a lot of these loans, they under 200,000 were, for the business and to the business, above 200,000 also for the business and to the business. But oh, by the way, you have a personal guarantee. And so these loans are now being sent to the Treasury for collection, and things are starting to get to the point where they're putting in motion the next level of collections. So
it's like a personal guarantee means that not only is the business responsible for that loan, but if as a business owner,
right,
if you did a personal guarantee, your own assets are on the line as well. So the Treasury can go back after the business and the owners themselves.
Yes, correct.
And that what puts their house at risk and such.
Yeah, absolutely. I mean, it would be a stretch to say that is your house going to get foreclosed over an EIDL loan? Well, if you used it as collateral, possibly,
Right.
but by and large, it doesn't, that would be an extreme point. That's the other end of the spectrum, right? That's when, people always go to the worst case scenario in their heads when they get scared.
Sure.
So that's the call I get. They're going to take my house.
Yeah.
Well,
But they could take your bank account.
They could, and they could do it much easier
Right.
than a regular creditor because they don't need to go through the judicial system because they have the treasury. And so they're able to do it in a quicker, shorter manner. Now, that being said, I have not seen it happen yet.
Oh, okay.
I have not seen people get sued for an EIDL loan. I have not seen folks get their bank accounts garnished for EIDL loans. What I have seen, though, is people have Social Security garnished.
Oh,
So
right.
there's people listening. Oh, wait a second. I thought my Social Security was safe. Like it was exempt from creditors, not from the treasury.
Wow.
So they can, take that part, take some 15% of your Social Security to pay a debt that you owe to the treasury. They can do that. There's, whether or not they can do it if it's a disability is another, but for the SSI income, yes, they can.
Wow. It's amazing how COVID can still impact us some 6 years later, and I'm sure it's going to continue to impact in so many different ways as well.
Right.
Jake, we're about to wrap up the show, but I want to give you the opportunity. We didn't even get to talk about all your areas of law, so I have to get you back again on popular demand to get you back to talk about your other areas of law. But in the meantime, how can people reach out to you?
I'm at 727-531-7068. My firm's Blanchard Law. Been on my own and had Blanchard Law since January 2014. I'm over in Pinellas Park, Florida, off 49th Street. Again, the number is 727-531-7068. My website is jakeblanchardlaw.com, and as egotistical as that sounds, I had to use it because I'm not the only Blanchard Law in the world, apparently.
Oh, wow.
So I didn't get the website. There was somebody that beat me to it. So I had to go with jakeblanchardlaw.com.
Oh, that sounds good. And if you didn't get that, but you still want to listen to our show, we do at the end of the show, we always post these shows onto our podcast channels. And so tomorrow you can find this show and all our past shows on our podcast, FLA Law on the Radio. We are on Spotify, Apple Podcasts, YouTube, and most other podcast platforms. This whole episode together with Jake's firm contact information will be on there as well. And so if you didn't get all that information, you can jump on the podcast and you can find that there. Jake, one last thing, 2 top takeaways for our listeners for today.
Eat your vegetables.
That's a good one.
And do the right thing. I mean,
You
from a
sound
legal
like Hulk
standpoint,
Hogan. You sound like Hulk Hogan. Say your prayers and eat your vegetables.
That's it.
That's
Say your
right.
prayers and eat your vegetables, brother.
That's right. No, I really appreciate you taking the time to listen to us. This is Matthew Noyce. I am the attorney at Pernick, Caulfield, Averill, and Noyce. We will be back next week. Jacqueline Bryant and Lori Robinson will be here to tackle questions that you have. I'll be back in May hosting the shows. But in the meantime, drive safely and watch out for those who don't. Take care.